right. Thank you for tuning in. My name is Ali Talai, and today I'm going to talk to you about why a trust is right for you. And before I do that, let me tell you a little bit about myself. As I mentioned, my name is Ali Talai. I'm an attorney here in Woodland Hills, California. That's where my office is. Beside having a law degree, I also have an advanced tax degree. It's called LLM in taxation. I also do a weekly radio show on 670 AM. It is in Farsi, so if you speak Farsi, please tune in. No subtitles. I'm also a real estate broker and a mortgage broker. I have those licenses. I don't really practice, but we work with a lot of real estate investors and individuals that own real estate, and it's been very helpful for me to have some background in real estate, so it enables me to be able to help my client better. Our website is there. My email address is there. Also, if you're thinking, you know what, I just want to hear more about estate planning, trust planning, asset protection, estate tax planning, please friend us on Facebook, follow me on YouTube and LinkedIn and all the social media channels. It'll be great to sort of connect. And having said that, let's start. Let's talk about why is a trust right for you. Let's talk about an ideal estate plan. Obviously, if we had a magic wand and we could do the perfect estate plan, we would want something that allows us to avoid estate taxes, something that allows us to avoid income taxes, avoid dissipation of money and property from irresponsible spending. And this is usually for our children when we're not here and they're left with a lump sum money. Sometimes it's easy for them to spend it on things that we wouldn't want them to spend it on. Also, we want to make sure we set up an estate plan that provides creditor protection from divorces and regular creditors and predators and all those sort of things. And also, it would be nice that we have something in place that there was no court proceeding, probate, guardianship, conservatorship, all those things. That would be the ideal estate plan. However, before we go to the next slide, I just want to mention to you that there's really not one kind of a trust or one plan that would enable us to do all these things that I named. However, we could put together an estate plan that could provide estate tax planning, income tax planning, asset protection, and all the stuff that we went through. So it is definitely doable. It's just going to take some time to make sure that it's done correctly. So let's talk about the different ways you could create an estate plan. I'm going to go through, I think, about 4 different things in general you could do. And the first thing, as you see, is you're really not doing a whole lot. Doing nothing, believe it or not, could be considered a planning. Very easy to implement. You don't have to do anything. Initial legal fee, none. So those are all attractive to some people. However, as you probably already know, unfortunately, doing nothing ends up costing your beneficiaries and loved ones much more at the end when we're not here and then they have to go to court and all the other stuff. The other thing that you can do, or the other sort of idea within what sort of plans I could put in place, is to use joint tenancy, beneficiary designation forms, and transfer on death sort of options. And a lot of times you see these with bank accounts. You see joint bank accounts. You see properties that says, husband and wife as joint tenants. And what joint tenancy does, realistically, when the first owner or the first part owner passes away, that interest that he or she had automatically transfers to the remaining owners or whoever is left. And it doesn't involve any court proceeding, but as you could see, for example, if it's father and son and their whole title is joint tenants, and now if dad passes away, his share will pass to the son. However, at some point when the son passes away, and if he hasn't done anything, then that would be a probate proceeding because there's nobody else on title for it to transfer. The other estate planning that we could do is a will-centered estate plan, meaning that we're going to use a will as the main document to be able to document our wishes as far as who's going to get our assets, how they would get it, when they would get it, and what percentage they would get. The next one is a trust-centered estate planning. And the biggest difference between a will versus a trust is that if a trust is done correctly and my assets are funded into this trust, at the time I pass away, there could be no there could be no probate proceeding, and eliminates any court involvement and the cost and the time that it takes to do these things. I'll go over a little bit in more detail in the few slides down. But that's really the 4 different options we have. And now we're going to go through them and sort of figure out what else are involved in these things. Estate planning is more than just documents. It's not just having one document that says what that it's sort of standard for everybody. That's one thing I get to see. Sometimes people come in and they have this notion, this idea that they think they're all the same, that a lot of attorneys or sometimes these legal Zooms and things like that, all they do is they just print the form and have the person's name printed on these things, or in many cases handwritten on the form. And the reality of it is, estate planning, trust planning, they're not all the same. And what we really strive in my firm is that we want to customize our estate plan to your individual needs, your family needs, the assets you have, and those sort of things, to make sure whatever plan we put together, it is something that is truly going to serve you and your family while you're alive and at the time you pass away. So we really strive in making sure that we create customized estate plan. And as I mentioned, estate planning requires thoughtful consideration for your goals and making sure that they're implemented in such ways. The other thing with estate planning, and especially about trust planning, I mean, we do stuff today, and obviously it's based on your needs today and what's happening today and the laws that we have today. But what's guaranteed in life is change. So what we offer in our firm, we offer all our clients a 3-year review, complimentary, and we want to check back with them, even if they don't like it. We like to call them and bug them, and we want to see if there's something's changed in their life, if we need to sort of update their trust. I give them an hour of my time without charging them anything. If we do have to do some updates, there's a fee for that, but the idea is that we want to sort of keep in touch. I ask all my clients to actually include their kids if they're older, if now they're at a stage that they understand these sort of process. I ask them to be in that meeting as well, and that way they get to sort of learn a little bit more as far as what estate planning is all about and what their parents have put in place. Mm-hmm. Unfortunately, when you lose a loved one, it's a tough stage, and it's always nice to have somebody to be able to sort of ask questions and talk to. All right, so let's talk about how your estate will work if you don't have a will. And this thing here, this is an example of all the assets, let's say someone would have. They would have their investments, bank account, heirloom, personal property, home, and other properties that we usually have. And that's all your estate. So now if for example, I haven't done anything and I pass away, what's going to happen is it's going to go that first plan that we talked about, doing nothing, zero upfront costs. It's reality. This sort of planning is so important that every state has done a will for everybody that lives in that state. It's called intestacy laws. So we're in California, and if, for example, a person doesn't do anything and they have all these things and they pass away, state of California's law would determine who would get it, how much they would get it, and when they would get this thing. And so if I have nothing, there's still a court proceeding, and there's going to be probate fees. If there are taxes to be paid, they get paid. There are creditor notification, 120-day credit notices that will go out and would have to be published in the newspaper. And probate in general, it's pretty costly in California. So to give you an example, if you have $1 million home, and that used to be a lot, and these days, it's not a whole lot, especially here in Southern California. But if you have $1 million home, the statutory fee in California, which is predetermined before a person passes away, indicates that $1 million property would have about a minimum statutory fee of $46,000. Yeah, $46,000. And it doesn't matter if the person owes money on it. So, for example, if this person has $1 million property, owes 800, the probate fee is not figured on 200,000. It's actually figured on still the gross value of the estate. In my example, $1 million. So that's the process here in California post-COVID. We're looking a minimum of a year to go through these things. So it's definitely time consuming. And this 46,000 that goes through attorneys and court processes and all that stuff, that really just means your kids are going to get less inheritance. So that's option one, not doing anything. It would have to go to court. And then after everything is done, your heirs will get the assets. Let's talk about if now we've used some joint tenancy in our estate plan. Quick little break here. If you're finding this information helpful, I ask you to share this video with maybe friends and family members you have that are looking to do a estate plan. Hopefully this video is helping you, and it will help them to sort of understand the different options that are out there, and it would enable them to make better decision with their estate plan and their trust and all that fun things that it's really necessary for all of us to do. All right, let's talk about joint tenancy. Joint tenancy. So in this example, I got this bank account, home and investment account. Those are usually items that could be under a joint tenancy. So let's say I'm a father, I have 3 children, and I decide that I'm going to come up with some sort of plan that allows me to direct each asset that I have to one of my children. In this example, I'm going to have 3 children. I have 3 different assets, and they're relatively about the same value at the time we're putting this thing together. So joint tenancy, I got the bank account, it goes to my 3rd child. And so what happens, I have an account, I add my son's name to it. At the time I pass away, he'll get the account without any probate. Then I got my home, I would do the same thing, add one of my other children to the deed, and then at the time I pass away, he or she will receive the house. The investment account or the IRA account would be the same thing. I could fill out the paid on death beneficiary of the account, and if I'm not married, I could just name my 3rd child, in this case my middle child, as the paid on death beneficiary. And sometimes people think that could be a good plan for them to implement in order for them to avoid paying an attorney to do some trust work, which in reality of it, this is sort of putting a band-aid on a broken arm. This is not the best way to do these sort of things, but it's definitely a way to do it. And so if we have a plan like this at the time of death, the beneficiary, the child, will receive the assets. There's still some work that needs to be done. For example, for the house, you still have to file an affidavit of death of joint tenant. So there's some work that needs to be done, but it's relatively easy, and there's no probate process or court proceedings. The only problem in most cases is that, for example, in my example, I may have a bank account that had 500,000 when I did this thing, let's say 10 years ago. And at the time, in my example, I'm going to say I had 500,000 in there. However, in most cases, I may be depositing money into the bank account, but at the same time, I have my own expenses. So what's left at 10 years may still be what I left in there, what I started with 500. And the point of this example is I want to show to you that sometimes trying to do this thing and hoping that I could get to a result that would be even distribution between my children becomes difficult in most cases because of change in value and taxes and different things like that. With real estate, This could go one way or the other. One is, let's say I had a home that was 500,000. By the time I pass away, I could have gotten a mortgage on the property. And now really the net value could be a lot less. It could go the other way. What's been happening in the last few years with real estate is that my property maybe it was 500,000 10 years ago, but now it's worth $1 million. So now, that the middle child is going to be very happy, or the first child, because they're going to get twice as much more in value compared to what I had initially intended. And then the third one, this is probably the one that sometimes people don't think of, these IRA accounts. And again, hopefully in most cases, the value has gone up. So if I started with 500,000, now it's 750, it's gone up. However, when the beneficiary starts withdrawing funds from these accounts, they're going to have to pay income tax. In most cases, these retirement accounts, you've contributed pre-tax money in there. So now when the funds come out, they'll have to pay income tax. They do not receive what's called a step up in basis. Investment accounts that are under a qualified plans do not receive any changes to the basis. Real property do, and other assets do. We'll talk about that more as far as basis in another video. So as you could see, it's really tough to have a joint tenancy plan in place and try to have a estate plan that enables me to be able to distribute to my children evenly. If I have a will, so we talked about no will, we talked about joint tenancy. Now, if we got nothing, right? I'm sorry. If now we got only a will. The thing with the will, or if I have nothing, it all still means in order to actually put this thing to work and have the asset distributed to my children or to my heirs, there would have to be a court proceeding. A will does not eliminate the court proceeding. The only thing it does is that I bypass what the state says my assets go to, who gets my assets. So for example, if I wish to give 10% to a friend, 10% to a charity, and the other 80% all to my first child, I could do that with the will. I could write that in there and the court would review it and validate it, and then that would be how my assets will be distributed, and the court would make sure that's how it would be done. But it doesn't eliminate the actual process of probate. Probate fees are paid, taxes are paid, and then after that, it go to the beneficiary. Probably not the best plan, particularly if you got a home in California. In California, if you have real estate that is less than $63,500, then there could be no need for a probate process. However, if you live in California, there is no real estate for $63,500. Maybe a piece of land in Palmdale or some of the cities that are outside of the main cities. All right, let's talk about a trust. This is probably in most cases, and if you're listening to this video, in most cases, it's going to be the type of planning that you're going to need, the type of planning that would make the most sense. And it's this thing called a trust. And the big difference between a trust is that you're saying the ownership of this asset, instead of being under my name, it's under my trust name. So we create the trust and we fund the trust. This slide is on partially funded, but you'll see the next slide is on fully funded. Ideally, we want to have the trust and then fund everything, meaning transfer ownership from our name to the name of the trust. Why this is important? It's important because at the time I pass away, that's how usually this probate stuff, it gets triggered. At the time I pass away, my trust doesn't die. My trust is still alive. Within the trust, I've indicated who gets my asset at the time I pass away. And then the person I have selected within the trust, the trustee, has the legal power to transfer assets. So that's why this thing becomes essential in the type of planning that we're going to talk about, and we do. All right. So partially funded, it just means that we have a trust, but we haven't transferred everything. In this example, I have a bank account. Let's say I have the $500,000 in there, and I just don't get around of getting it transferred. This is very common. We do a lot of court proceedings to to go to the court and ask the court to give us an order to be able to transfer this bank account into the trust. It doesn't mean we have to do the full-on probate. It's a shorter probate process, but nonetheless, it still means probate, and it still could take 2-3 months, and attorney fees to do that sort of portion of it as well. So ideally, you want to do a trust, and then you also want to fund the trust. All right, so now let's talk about a fully funded trust. This is what, in most cases, what we would want to do. Another point I want to mention, when you don't have a trust and you go to court appoints someone and gives them the power to be able to legally sign on behalf of the person that passed away. They call them executor, personal representative, administrator, that person. Within a trust, we don't need a court proceeding to give someone the power to be able to sign. The trust instrument gives our successor trustee, the successor manager of the trust, that power already. So that is one of the distinctions, one of the other distinctions between a trust and a will. And that's why we don't need a court proceeding, because whoever we named as a successor trustee has the power to sign. And that becomes important because if you have a house and it says it's going to go to, 3 children equally, there needs to be a deed that would transfer the property from the trust name to their name, and probably better to their trust name. In most cases, we recommend that we actually would create a trust in the parents' trust for the children. So now it gives them asset protection, creditor protection against divorces, and those sort of things. So we got the trust, we got all the assets, they come in. While you're alive, you use the asset. There's no changes to it. You could do whatever you were doing before. You could do 1031 exchange. You could rent them, lease them, get a mortgage on them. It doesn't affect your ability when we're talking about a revocable living trust. And then at the time you pass away, your beneficiaries get the assets. And there's no probate fee as long as the trust is fully funded. There's still going to be some fees. I don't want you to think if you have a trust, automatically everything goes to the kids and there's absolutely no fees. There's still some fees because there has to be some paperwork filed. There's some state notifications requirement, those sort of things. But it's definitely less expensive, and it's definitely much faster to get done. And then if there are taxes and things like that, that would be paid. If you have a state that is larger, if you got a 10, 20, $30 million worth of estate, then what we would want to do, and we talked to a lot of our clients that have a larger estate about advanced estate tax planning, asset protection planning. Those are all other things that we could do with the trust. There are numerous types of trusts and different reasons why we would use one versus the other. And that's something that we would talk more with our client when we meet with them. This slide kind of goes through all the options. Again, doing nothing, joint tenancy, will, and a trust. I'll leave that here if you want to take a picture, or if you want to just refer back to it. It's at the end of the video, and that gives you more information. I hope this video was helpful. My goal here is really here to provide you value, give you more information about estate planning, enable you to make better decisions about estate planning. And if you work with us, great. But if it doesn't work out, I ask you to work with somebody else, a competent estate planning attorney. And this video hopefully enables you to ask better questions, and you could have a better plan that saves your estate against probate, so your kids get to enjoy more of the hard-earned money that you work during your life and what you leave to them. All right. Well, thank you so much. If you enjoy this thing, please follow us on Instagram, subscribe to our channel on YouTube, and share the video with your friends, your family members, and hopefully they will get something out of this video as well. All right. Thank you so much.